Madam Clerk. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court. Good morning. Welcome to your Supreme Court. The court calls 276A19-1 in re B.L.H. Mr. Gillum.
Thank you, Madam Chief Justice and Associate Justice. May it please the court, my name is Lee Gillum. I'm an Assistant Parent Defender in the Office of the Parent Defender, and I represent Respondent Father. I thank the court for the opportunity to present my client's case and have a conversation about this important issue, and I would like to reserve 10 minutes for rebuttal.
You may.
This case presents a very simple question, and that question is whether the trial court must include its standard of proof in a termination of parental rights order. In re Church, which was a case decided by the Court of Appeals, said that the trial court should include the standard of proof within its order. And because the trial court did not do that in this case, the order should be reversed so that the trial court can look at the evidence under the correct standard of proof. And to get to that result, we're asking the court to reaffirm Church in its full measure and affirm a commitment to procedural due process in these cases, and look at a case which was recently decided by the Court of Appeals. It came in after the case was briefed. That is Dunn v. Covington, and underpin Church with the Constitution instead of the statutes, like Church itself does, and communicate to the trial courts the importance of these cases and the importance of looking at the evidence with the correct standard, and that is clear and convincing evidence. Simply stating the standard in open court, as DSS and GAL have both argued as dispositive, should not be dispositive in this case. And there's a couple of reasons for that. Two are general propositions, and the third is specific to this case. The first is that as a general proposition, a termination of parental rights is a grave and drastic result. And because it is so grave and so drastic and so harmful to a family, the court should ensure that every procedural protection that's applicable should be followed to a T. The second reason is the written order is always controlling in cases, and if the written order does not have the standard of proof, then the written order in the four corners of the order is not adequate to support the judgment. Now, specific to this case—
Mr. Gillum, let me ask you a question. Do you contend there's any statutory authority that expressly requires a trial court to put the standard in the written order?
The Church applied 7B.1109 to reach that result. Now, I will concede that 7B.1109 does not state, as 7B.807 does, that the court must state that it made findings by clear and convincing evidence in the order. But Church read the juvenile code as a whole and said, if it's needed in the underlying case, which doesn't have nearly as drastic a result as a termination order, then by implication it should be in the termination order. But there's not a statute that specifically says you must state in your written order a clear and convincing standard of proof.
What is the most relevant statute dealing with this issue in terms of what the trial court's required to consider?
7B.1109 says that the findings have to be made by clear and convincing evidence in a termination of parental rights case.
And has there been any case from the Court of Appeals since Church which has held that it's insufficient for the trial court to state the standard of proof orally, even if it's not contained in the written order?
I'm not aware of one, but I'm asking this court to do that because of Dunn v. Covington, which I can discuss now, which was a Court of Appeals case that was a lesser case than the termination of parental rights. And if you'd like me to go ahead and get into that, I'd be happy to do that. But before I do that, let me just say that the findings in this case in the written order were much more extensive than in the transcript. In the transcript, the trial court announced that it would be making the findings by clear and convincing evidence, and then it proceeded to make summary findings for each element of respondent father's case plan. And by adding those findings, I would like you to hold that stating the standard at the hearing on the transcript is not sufficient, because this court needs to know, when it reviews an order, that the trial court applied the standard of proof to every single material finding in the order, and it did not do that in this case. And it should have put that in the written order.
Well, counsel, while you say that the written order of the trial court is controlling, is it exclusive such that we should not consider what was said in open court?
I'm saying that the written order controls, and there's a lot of authority that says that. I've put a case in my memorandum of additional authority called ODS that says the written order controls, and I think that's consistent with other types of cases where there are bench trials and not jury trials. But the written order has to stand on its own, on all within the four corners of that document, because of the importance of the cases. And want somebody to come back and see the written order later and say, oh, well, this case was not established by clear and convincing evidence because it's not within the four corners of the document. And again, if you make the rule, which would be consistent with the Court of Appeals holdings, if you make that rule, I think you have to say that in this case, it doesn't fit because the written findings are so much more extensive than the oral findings.
What would be your response to the DSS position that N. Ray O.W. would represent that the trial court's statements, both in open court as well as the written order combined, would be such that it's not mutually exclusive one way or the other, and that as long as a trial court says between the oral rendition of the order and the written rendition that cogent and convincing evidence is recognized as the standard, that is sufficient? What's your response to that?
Well, I'm asking you to make a rule, again, because of the importance of these cases, that says that the written order has to be sufficient within its four corners, and that written order must show that all of the material findings in that order were found by clear and convincing evidence. And even if you make a rule that the order should contain, the written order should contain the standard of proof, stating the standard in open court is sufficient if the findings are not materially different. And if the findings in the written order, as this case, are materially different and much more extensive than the findings that were dictated in open court, then that rule does not apply to this case, and this case should be reversed because of all the additions to the written order.
Is there anything, Mr. Gillum, in the trial court's written order that suggests that the trial court applied any standard of proof other than the required one?
I don't think there is. I think, as I remember the order was silent on the standard of proof, except there's one case where the order refers to the underlying adjudicatory order and says the underlying adjudication facts were found by clear and convincing evidence.
So the problem with the order here, as you see it, is its silence rather than any affirmative statement that suggesting that the trial court used the wrong standard of proof.
Yes. I think that the rule should be, and again, because a termination of parental rights order is, and I think that's the most serious order that is entered by a trial court. It completely destroys the family. The parent has no standing at a later time to get visitation or custody or anything else back. And because these orders are so serious, the procedural aspects of them protection should be very strictly observed, and that includes putting the standard of proof in the written order so that there can be no question when somebody looks at the order at a later time that the trial court followed the clear and convincing standard of proof.
Is there any, go ahead.
No, please continue. Go ahead.
I'm sorry. Is there anything that would distinguish this case from the cases in which the Court of Appeals has upheld orders based primarily on statements made by the trial court during the oral rendition, except the point that you've made several times about the difference between the extent of the trial court's findings orally and in writing?
I think if this court follows the Court of Appeals precedent post-church, then the findings are probably, or stating the standard of proof in open court is probably adequate for the case. But okay. I'm asking you to go a step beyond what the Court of Appeals has said and make the rule that we think this is so important that you have to put it in the written order.
Okay, thank you.
Yes, my question was to follow up. I understand your position that you want us to rule that what's in the written order is controlling and only what's in the order. But I just want to know if, on your view, there's anything in the record at all. So anything that happened during the hearing or anything that the court said in open court that suggests the court was applying a standard of proof other than the clear, cogent, and convincing standard.
No, there was not. That I remember from reading the transcript. But again, as the court said once, absence of evidence is not evidence of absence. So I think that if it's not clearly stated in the written order, then the trial court has not done its job of making the findings of evidence.
Mr. Gillum,
yes.
Have you challenged any of the findings of fact specifically in this case as not having been supported by clear, cogent, and convincing evidence?
There was one finding specifically challenged in the brief, and that was the finding regarding the judicial establishment of paternity. The brief makes more of a general challenge, and there's a case I cited in my memorandum of additional authority that when a finding is made under a misapprehension of law, the case has to be sent back to the trial court to make sure that all the findings have been made by the proper standard. Because without the proper standard, none of the findings have the force of a fully convincing finding. And in this case, without that, you need to make sure that all the procedural protections that are accorded to a parent are followed. And the only way to make sure of that is to make sure that when the trial court writes the written order, they put in there that, yes, I made all these findings by clear and convincing evidence, and I am fully convinced that the evidence supports grounds for terminating this person's parental rights.
Well, other than what the trial court said in open court, is there any indication in the record that he applied any other standard other than the one in the statute?
No, there's not. There's no other evidence within the transcript or another statement in the transcript that suggests the trial court is not applying the correct standard of proof. But what I'm asking you to do is to, again, recognize how serious these cases are and hold the trial judges to a very high standard, and not just assume that because there's no statement of the standard that suggests otherwise, that we presume that the court used the correct standard. I think these cases are, not to repeat myself, but they're just so important that the procedural protections that are in place must be followed strictly by the trial judges to support their orders.
But if we would agree with you that the written order certainly would be enhanced with a clear statement that it was based on clear, cogent, and convincing evidence, yet on the other hand, it was stated in open court that that was the standard that was used, and going into this case, there was not a clear indication that that was required, then why should reversal be the cure here for that lack of the statement in the written order? Isn't that a bit extreme considering the circumstances coming into the case?
It might be extreme in a lesser case. I don't think it's extreme in this one. I will note that Church remanded the case for the judge to indicate in his order that the correct standard was followed. That would be a way to resolve this case. But I think the best way to resolve this case is to communicate to trial courts. We have a very high standard in a case like this. It's been called the civil death penalty, and it really is. We have a very high standard, and you have to meet that standard, and we don't make any exceptions for that. So yes, it's a it's kind of a, as I think you said, extreme result or a harsh result. But I think the harsh consequences that come with the termination of parental rights order require a harsh review of those termination of parental rights orders to make sure that every procedural protection is followed.
Well, reversal would be harsh in the sense that this court would be determining that the trial court did something wrong, but yet here, even you have admitted that in response to my learned colleague, Justice Davis, that there's nothing statutory in place to require that a written order contain the standard. The standard was said verbally, and there's no indication, as you candidly admit, that there was any other standard that was applied. So am I hearing you suggest that if we would decide not to have a harsh result such as reversal, that a remand would be appropriate here in your eyes?
That is not what we're asking for, but I think that is a way that you could resolve this case without almost taking the clear and convincing standard out of a termination of parental rights hearing, because that written statement in the order, I think, really impresses upon everyone that's involved in the trial court, including the judge, how important these things are. And there's lots of things that we require to be in writing, such as, for example, real estate transactions. And a real estate transaction has to be in writing because it is just so important. And it affects a lot of other things. In the same way, I think is true with a termination of parental rights order. It's permanent, and I think this court should impress upon every trial court that the procedural protections that are in place for these cases must be followed strictly. And if you're not, we're going to send it back for you to do it over again. If there's no other questions on that, and with the court's indulgence, I'll talk about Dunn v. Covington, which was decided after the briefs were filed in this case, and it's fairly recently. And Dunn talks about the constitutional basis for the clear and convincing standard of proof. And it's important to note that Dunn is a Chapter 50 civil custody case. It was a case where custody of a child was given to the grandparents, and a Chapter 50 order is always modifiable. A parent can always come back and ask for that order to be modified to get themselves visitation or even return custody if the circumstances in that parent's life change and the court determines that that change is substantial and the best interest of the child is to go back with the parent. And Chapter 50, unlike Chapter 7B, does not have anything in it about making findings by clear and convincing evidence. But Don relied on a U.S. Supreme Court case, Santosky, which this court relied on just a few weeks ago when it decided EB, and also David N., which was a case from this court, which was also a grandparent custody case. And those two cases said that if a trial court finds a parent to be unfit or to have acted inconsistently with the constitutionally protected status of a parent, the court must make those findings and state the standard of proof as clear and convincing evidence. Now, Dunn is different from this case, and that in Dunn, there's no indication in the record that the trial court stated the standard of proof during the hearing. But it does support making a high standard for termination of parental rights because, as I said, Dunn was a modifiable order. Termination of parental rights it's over. And Santosky, which Dunn relied on, talks about the fact that termination of parental rights is a unique deprivation of a precious liberty interest both to the parent and to the child because it can't be undone. Now, there's been a statute passed here since Santosky that the DSS or the guardian ad litem can move to have parental rights restored, but a parent can't. A parent simply does not have standing to do that. And Santosky, again, which was the basis for Dunn, said that the finding of parental unfitness, because it impacts a constitutional right, should be found by clear and convincing evidence. And one reason, as I've said, is the stark consequence. And the other reason that Santosky gave for the clear and convincing standard is because there's such a mismatch of contestants in most termination of parental rights cases. And in a termination of parental rights case, generally speaking, the parent is not well educated. They don't have many means. There's usually some issue in their life, like substance abuse or a domestic violence relationship that really puts them on the margins of society. And on the other side, you've got this county agency that's paid with taxpayer funds, can hire experts, social workers to investigate. And one thing that Santosky pointed out is that the agency can write the history of the case as it goes along, because almost all the reports that are entered during the pendency of the case are written by social services. And because social services has all that power on its side, then the department is held to a higher standard of clear and convincing evidence. And like I said, if clear and convincing evidence was required and done, how much more should it be required in a termination of parental rights case because of the unique deprivation and because of the mismatch of the litigants? And
let me ask you a quick question about this. Even if we agree that it would be a good idea for the trial court to state in the order what the standard of proof is that they're applying, isn't that specific requirement that it be in the order, that it be stated in the order, something that should be added by the legislature? And if not, why not?
Well, if it's in the Constitution, it doesn't need to be added by the legislature. That'd be my first point. Certainly.
Well, the Constitution doesn't specifically say that you have to say in a TPR order that it's based on clear, convincing evidence. Correct?
Right, but how does the reviewing court know if it's not stated in the order? If the order is materially different from the findings at the hearing, how does the reviewing court know that all of the findings in that order are by clear and convincing evidence? So what other mechanism is there to hold the trial court to the standard that is required by the Constitution if it's not required to put that statement of its standard of proof in the written order?
Even like I said, like I asked a minute ago, even if we agree with that, why is it the job of the court to add that specific requirement as opposed to the legislature, since we're dealing with a statutory scheme here?
Again, because the Constitution does serve as the backstop for all cases that infringe on our liberties, and termination of parental rights most definitely infringes on liberty, and it infringes on liberty in almost the worst possible way that we can imagine. Most parents that I know would rather spend a couple of years in prison than have the relationship with their parent cut off forever. And if it pleased the court, I would like to save the rest of my time for rebuttal.
You certainly may. I understand that Mr. Wolf and Ms. Chutt will split their time on behalf of the appellees.
Ms. Chutt, you're muted. Ms. Chutt, you want to unmute? No, it's easy to have that happen. Oh, and you remuted yourself. Hey, Ms. Chutt, can I get you to unmute? There you go. Okay.
You just muted yourself again.
Yeah, I think we're having Ms. Chutt. Go ahead and unmute. Are you using the space bar to unmute, or are you clicking? Okay. There you go.
Good morning. May it please the court. My name is Mercedes Chutt, and I'm arguing on behalf of the Guilford County Department of Health and Human Services. I will be sharing my time with the attorney for the guardian ad litem, Mr. Matthew Wolf, and we had planned on splitting our time equally. So that means I would have 15 minutes and Mr. Wolf would have 15 minutes. If that pleases the court. So this is a case where this case does not, in my opinion, involve complex constitutional issues. It is a case where the court was very clear on the record, stating the standard of proof in a near textbook type manner. The court stated that before making the findings of fact, before orally rendering the findings of fact, the trial judge did state that the findings of fact were being made based on the sworn testimony of the social worker and decided under clear, cogent, and convincing evidence. Now, in this case, the written order does omit the terms clear, cogent, and convincing evidence. The better practice by far, of course, is to include that language in the written order. And I would certainly not argue that that language should be omitted or that it is not applicable or that any constitutional protection for parents should be remotely relaxed. Obviously, parents have constitutional rights to raise their children. Obviously, these are very important cases and they need to be treated very importantly by all trial courts. And I do not believe that this is a case where the trial court did not treat this case appropriately and give the father every protection offered under the Constitution and the laws of our state.
Ms. Chutt,
yes.
What rule are you asking us to announce going forward? Is it required that the trial court either state the standard of proof orally or put it in the written order? Or alternatively, are you saying that it doesn't need to be spoken, need to be set out verbally or put in writing?
What I am suggesting is that the court adopt the reasoning in the Court of Appeals opinion in Ray MD. And as I read that opinion, what the court was faced with a similar set of facts, not the same set of facts. And unfortunately, none of the Court of Appeals cases, I believe, address exactly the same set of facts. But in Ray MD, the statement of the standard in the written order was clear and cogent. And on the record, the court said clear, cogent, and convincing. And in MD, it appears to me that what the Court of Appeals did is that they looked at the entire record first, the first prong, to determine if in the entire record it was clear that the trial court, used the standard clear, cogent, and convincing. After having concluded in the entire record that the court did use the proper standard, the Court of Appeals at MD then went on to look at the question, which I think is very important and I think touched on by Justice Hudson, which is, did the parent suffer any prejudice as a result of failing to, written order, failing to make clear?
Before we get to prejudice, I want you to tell us, what is the rule that we should adopt in your view? What exactly is the trial court required to do?
So in answering your question, I think the trial court is required to state either in the written order or on the record that the findings of fact are entered on clear, cogent, and convincing evidence. And if you look back at—
just so we're all clear, what is the statutory authority for requiring that even be stated, much less written?
So there is no statute. Okay. If you go back to In Re Church, to answer your question, I have to go back to In Re Church. In Re Church looked at the companion statute, which was 7B-807. Well, that's what it is today. That it was another number because it was a superseded statute, but the language is pretty much the same. So for adjudications, the statute requires the trial court to state on the record clear, cogent, and convincing. Now, 1109E, 7B 1109E, which is a statute that applies to termination cases, is silent on stating on the record. It says only that the court should enter findings based on clear, cogent, and convincing evidence. The underpinning of this requirement that the order contain the language clear, cogent, and convincing evidence, the written order, comes from Church, and it comes from Church interpreting the statutes under 7B in para materia. There is no order, there's no statutory authority that applies specifically to termination of parental rights in terms of the written order requiring
is the language upon which the Court of Appeals relied in Church still in 7B-807?
It is. It is. It says the court shall state on the record, well, the court shall state. And it's unclear in whether that means stating on the record or stating in writing, or it means either or. And the Court of Appeals, in cases more recent than Church, have certainly applied, in my opinion, an either or standard. You see that in OW, where the Court of Appeals said, there's no requirement as to exactly how the standard should be stated, whether it be in writing or it be verbally stated by the trial court when rendering the order.
Are you expressly asking us to overrule In Re Church?
I'm not. Well, I think I think the Court of Appeals has already overruled In Re Church, since In Re Church, I believe, was decided in 2000, and cases after In Re Church did not apply In Re Church to the letter. I think there's a distinction. It's unclear to me when I read In Re Church if the trial court did make the statement on the record that the trial court did here, which is stating very clearly that the standard is clear, cogent, and convincing evidence on the record. So I don't know if NRA Church addressed this particular set of facts.
So are you saying that you believe the Court of Appeals itself has overruled NRA Church, or that it has distanced itself from it by not applying it actively since?
I think that's a hard question for me to answer because the Court of Appeals has not, to my knowledge, expressly stated or held that NRA Church is overruled using that language, but I do believe it has distanced itself from that from NRA Church.
But you're not asking us to overrule it. You're asking us to do what with it? If anything,
distinguish it. I'm asking this court to distinguish NRA Church and to apply the analysis in MD, where the court looks at the whole record and says, and asks the question, is it clear from the record what the standard of proof was, what standard of proof was used by the trial court? And I argue it is clear from the record that the trial court did use the appropriate standard of proof.
as I heard your answer to Justice Davis's question about what should a trial court do, I wrote down that your answer was that the trial court either state the standard in open court or in the written order. Sounds like you're saying that the trial court in the present case did what the DSS is saying is appropriate to do in these kinds of cases going forward. Am I hearing that correctly?
Yes, that is our position because the statute, the underpinnings for church were that it has to be stated on the record. That's my interpretation. And so the record does state the standard of proof. And I think it's not in dispute that the trial court did not use the appropriate standard because the trial court made it clear, which standard it was using before it entered the findings of fact. Even if you look at the transcript with arguments of counsel, I believe that the father's counsel argued that in the closing argument referred to the standard as clear, cogent, and convincing evidence. So I just don't think that there's a basis for assuming that the trial court did not understand the applicable standard. And I think that the appellant's argument requires this court to assume the trial court did not understand the applicable standard. And I don't think the record permits that assumption. And if I may,
Ms. Cho, what should we do in your view if we have an appeal in a TPR case where there's no recitation of the standard of proof by the trial court in either the TPR written order itself or the oral rendition of the ruling?
Well, in that case, I think that vacating and remanding is probably appropriate. And I just would like to add that the appellant is actually asking for a unique remedy under the case law, because I have not located a Court of Appeals decision that would reverse under these, because the standard is not clear. So vacating and remanding is appropriate. There's absolutely no indication as to what standard is used in the record. None. If that's your hypothetical, Justice Davis, then that poses a serious issue, and it's a different issue than this case.
I'm sorry.
Go ahead, Justice Davis.
Well, thank you. Just really quickly, I'm just curious as to why you're taking the position that there has to be a statement either verbally or in writing after you've represented that there is no statutory authority requiring either.
Well, there is no statutory authority, and that could be argued, certainly, and I think I argued that in my brief, that it isn't required. I think that I'm basing this on the Court of Appeals precedent, which, of course, this court has the authority to disregard. So I'm basing the argument on looking at precedent as common law authority in connection with interpreting the statute. So I think that there is some precedent, but the statute, the strict letter of the statute, does not make this requirement.
I'm sorry, Justice Morgan, your turn.
Well, I'll make it quick because it's just building on what Justice Davis had asked, and I was going to go there also, but actually, Counsel, are you premising your position concerning the lack of statutory authority based upon what Justice Hudson had raised, that would be more for the legislature to introduce as opposed to this court?
I am, because if you look at the statute, the only statute that's applicable to the termination proceedings, which is 1109, I believe, E, simply states that the court has to use the standard of clear, cogent, convincing, and it does not require a statement. It doesn't require anything in the written order. That language is not ambiguous to my reading. And so therefore, when one applies principles of statutory construction, it's unclear that any court has the authority to interpolate language into the statute.
Thanks, Justice Earls.
Yeah. So my question is also precisely on this issue. While the statute doesn't specifically and explicitly require this, isn't the purpose for having the trial court state what standard of review it's using useful for appellate review purposes? I mean, and doesn't this court have the authority to say what we need trial courts to do in order to preserve our ability to effectively review their judgments?
Absolutely. Absolutely. I agree 100% with that statement. And we are not arguing that this practice, which has become a standard practice, which is to state the standard of proof in the order, I would never recommend that my client abandon that practice. This is a clerical error. If the court looks at orders from the Gilbert County Department of Health and Human Services, this is a clerical error. We always state the standard of review in our orders. The question, I believe, is what is the effect of this mistake? And is it reversal? And I would argue there's no authority for reversal. Is it remand? Possibly, although I don't know that that's necessary, because I believe that the standard of proof is clear on the record itself. And I would just like to mention, as I'm running out of time, so I have a very short amount of time here, so I may run a minute into my colleague's time, that if you look at In Re MD, they're also looking at, did the appellant make any meaningful challenge to the evidentiary findings? And I think that that is important because the standard of clear, cogent, and convincing evidence applies to the court's findings. So where the appellant did not meaningfully challenge the findings of fact, it is not clear to me that it makes sense for the appellant to raise this type of objection or this type of to appeal on this type of issue. And in this case, and just to touch on something that Mr. Lee was talking about, in this case, the appellant did not actually present any evidence in the adjudicatory phase of this hearing. The only evidence was from the social worker. And so and I argue, if one looks at the record as a whole, that the social worker's testimony very clearly supported all the court's findings of fact, the testimony and the record as a whole, which, and I would also, so there's really no, logically, I think it's hard to come up with a compelling legal argument that the findings are not supported by clear, cogent, and convincing evidence. And also, the court in MD did look at the issue of prejudice. And in this case, there's only been one challenge sort of touched upon to the findings of fact, that was to whether or not the father had established custody prior to the termination proceeding. And that goes to one of the grounds to terminate parental rights. That goes to 7B 1111A5. There were 4 grounds found by the trial court to terminate parental rights. And so we had neglect, 1111A2, and abandonment, 1111A7. And I do not believe that any time, so that was not, there's no challenge to the findings that support those grounds. So it's one of the reasons why I questioned in my brief whether this argument was even moved. If you're not going to make a challenge to the findings, the if under this case law, the findings are deemed conclusive on appeal, it's unclear what the point is of raising this type of issue. I think that it would have been appropriate for the appellant to make an evidentiary challenge to the findings if such existed. This is the one appeal, and those issues had to be brought forth on appeal under Rule 20A. And I'd also just briefly like to say that, of course, all these cases involve constitutional issues, and I think it's appropriate that we talk about the Constitution. However, the appellant did not raise any constitutional issues in his brief. And so I don't know how appropriate that is then under the appellate rules for us to delve into constitutional issues. So I would like to end by saying that I think this is a narrow set of facts where there are no findings that are challenged that can affect the outcome, and where the trial court made the standard of proof very clear on the record. I would argue that under these narrow facts, that this is consistent with the Court of Appeals cases after Church, and that the court, and maybe even Church, because Church did not deal with the situation where, that I can tell, where the court stated the standard on the record. So I argue that under these narrow set of facts, that remand is not necessary because the standard that the court used was clear. Thank you. And now I'd like to turn to my colleague, Mr. Wolf.
Thank you, Madam Chief Justice, and may it please the court. Matt Wolf with Parker Poe, Adams, and Bernstein here today on behalf of the guardian ad litem. This case is about ensuring that when a trial court states in open court that is making all findings of fact based upon clear, cogent, and convincing evidence as the statute requires, and then enters a written order with those findings, that the order is upheld and the termination is made permanent. There are two important considerations that have been raised today in discussion. I'd like to begin by talking about those. The first is what was raised by appellant's counsel and what I believe Ms. Shute and I agree on, which is the importance of the clear, cogent, and convincing standard to protecting the natural parent's constitutionally protected due process rights. That is not an issue in this case, and regardless of how this court decides this matter, whether it affirms it as we are requesting or reverses it or remands it, the clear, cogent, and convincing evidence standard is established in this court's precedent in statute, and this case is not going to lessen or in any way deteriorate the importance of that standard. The second is what Justice Earls touched on, which is the importance of this court's ability to engage in meaningful appellate review of these critically important termination of parental rights cases. And in fact, if we look at some of the cases that were cited by appellant's counsel, including the one that was presented last week, Dunn v. Covington, they touch on the importance of this court being able to look and determine whether the trial court applied the correct standard, and then if challenges are raised to the sufficiency of the evidence or to specific findings of fact or to whether the findings of fact support the grounds for termination or conclusions of law, that the appellate court is able to do that. But in this case, none of those challenges have been made. Appellant father did not challenge any of the grounds for termination. Appellant father did not challenge any of the findings of fact that are the basis for the grounds for termination. Appellant father did not challenge any of the conclusions of law or any way argue that the conclusions of law were not supported by the findings of fact. Appellant father has not challenged the sufficiency of the evidence. Appellant father has not challenged that the trial court applied the incorrect standard of proof to make the findings, and the appellant father does not challenge that the termination was in the best interest of the child.
Mr. Wolf,
yes.
Do you agree with Ms. Jutt that it would be reversible error for the trial court to not state the standard of proof either in the written order or in the oral rendition?
Yes, I think the statute makes clear that the trial court has to apply that standard to these cases. And if the trial court does not state it in open court or in its written order, it would be unclear for this court or for the parties below to know whether the trial court had applied that standard. Now, whether it needs to only be in open court and written order, I think there could be some questions about it. I don't think the court necessarily has to reach that issue in this case. Certainly, Church and the cases that were decided subsequently by the Court of Appeals make clear that that a court can go beyond the four corners of the written order to determine whether the trial court applied the correct standard. And I would direct the court's attention to MD, which Ms. Schutt referenced, which specifically stated that and relied upon the fact that the trial court orally indicated that it employed the appropriate standard. And then further, in relying upon MD AB, which again relied upon the fact that the trial court did make an oral rendition stating the appropriate standard. And then finally, EM, which was decided by the Court of Appeals in 2016, that states, quote, "The failure to state the burden of proof in the written order is not reversible error if the court states the appropriate standard of proof in open court." I would have concerns if there was ambiguity as to what standard was applied, or there was some conflict between what was stated in open court and what was stated in a written order about both the parents' constitutionally protected rights and this court's ability to engage in meaningful review. But those concerns just simply aren't present in this case. The trial court stated the correct standard in open court, applied the correct standard in the written findings, and this court has the ability to engage in meaningful review to determine whether the record shows that the standard of clear, cogent, and convincing evidence was met. Because the appellant father did not make any of those challenges, those are waived and therefore are binding on appeal. But even just sort of engaging in the hypothetical, it's unclear why this court could not, in this case or in any other case, be able to engage in a meaningful review of the trial court's decision when the trial court makes clear what standard they're applying and that it is the correct standard that is statutorily required. I want to also go back to a comment that Justice Hudson picked up on, and I think Justice Davis, some of your questions have alluded to this as well, and that is while Mr. Gilliam argues about why a rule should be in place, what he is actually asking for is an additional statutory provision that is not contained in 7B. And the General Assembly has shown an ability in many situations when it wants certain things in writing to be able to specifically include that in the statutory language.
On the other hand, Mr. Wolf, it's also true that the General Assembly is presumed to know what the courts have been doing in construing its statutes, and we've got a fairly lengthy history at this point of decisions by the Court of Appeals requiring trial courts to state the standard of proof, but finding that there's no need for a redo if some other evidence in the record suggests that the correct standard was applied. Is there any basis for thinking that the legislature may, by inaction over an extended period of time, have acquiesced in that approach to this problem?
So I think if this court adopted the same standard in that the Court of Appeals has laid out in Church and its progeny, including MD and AB, there would be no need for legislative action. That is, there would be no need for the General Assembly to come back and change it, because it would be, I think, consistent with the existing statutory authority, which requires the trial courts to use the clear, cogent, and convincing evidence standard. But what Mr. Gilliam is asking for is not, and I appreciate his candor. He is not asking for this court today just simply to adopt Church. He's asking for a new rule and an extension and enlargement of what is said in Church, which is that only the written order can be considered when determining whether the trial court applies. Are you asking us essentially to follow the line of Court of Appeals decisions that have followed Church, or are you asking us to do something else? Well, I share some of the concerns that Ms. Chute raised in her brief about the basis of Church in terms of the statutory interpretation. So I don't know that it's necessary for this court to adopt Church in its entirety. I do think that if the court just looks first to the statute, and looks to the line of cases which have all made clear the importance of the clear, cogent, and convincing evidence standard. I think it can come to the same conclusion that the Court of Appeals has come to if you read all of its cases together, which is that the trial court must state on the record, which can be in open court or in its written order, that it is applying the clear, cogent, and convincing evidence standard to the findings of fact. I don't have any.
So are you asking us to overrule Church, or are you asking us to basically continue down the road that the appeals has been going for the last several years?
Yes. So I don't think it's necessary for this court to overrule or abandon Church. I think Church was decided at a time when the issue of whether the trial court stated in open court the application of the correct standard was certainly not addressed in the opinion, and I could not locate it in the record in that case. I think the Court of Appeals subsequent decisions after Church make clear that it would be appropriate for a reviewing court such as this court to consider open pronouncements, or excuse me, oral pronouncements in open court as to the application of the appropriate standard. Now, I want to make clear, I agree with appellant, and I believe you cited ODS for this, that the written order would control. So in a situation where there is conflict between what was stated in open court and what is stated in the written order, that the written order would control. But that's not what we have in this case. What we have in this case is that the court in open court stated the appropriate standard, and then in the written order was silent as to the standard of proof. So there is no conflict, and so it's not necessary to adopt a rule that would essentially say what the trial court says in open court on the record is immaterial, and we're going to impose this additional burden. And the trial court, to be clear, in these cases already has a significant amount of burdens, and I think those burdens are well placed. They're grounded in the Constitution and the statute. So this court, if it affirms the termination case as we are requesting, is not letting the trial court off the hook. It is still making clear the importance of applying the correct standard and ensuring that findings of fact support the grounds for termination, again, all of which have not been challenged in this case.
Well, and you said on your on page 6 of your brief anyway that you didn't feel like Church had any applicability here. So in that sense, we wouldn't be overruling it or following it. We just wouldn't be applying it.
Yes, that was the answer I was trying to give previously, but you answered it far more succinctly than I did. I don't think it's necessary to overrule or adopt Church in this case. I see my time has expired. I appreciate the court's time and attention. Thank you very much.
Thank you. Mr. Gillum, rebuttal.
Yes, thank you. Just want to note that the agency has called the omission of the clear and convincing standard of proof in the written order as a clerical error. And that makes it sound like this is just a technicality and a formality that we stick in orders. But I think the termination of parental rights is a grave and drastic thing to do. And putting something in writing, we just know gives a certain solemnness to that, and an understanding that we have done something serious here. We have to put it in writing. And I think the court should communicate to trial courts how serious this thing is, how important it is to scrupulously follow all the procedural protections that are in place, and at the very least, in its written order, but that it's finding the facts by clear and convincing evidence. And I think if we make an analogy to criminal cases, which some are not the same infringement of liberty as the termination of parental rights case, I don't think we'd ever let it go by if the judge forgot to tell the jury that the charges had to be proved beyond a reasonable doubt, because, well, everybody in America knows that because you took civics class or you watched TV or something. We would require, I think, the judge to have made that very clear to the jury. And it's the same applies to this case. If the judge doesn't take and write clear and convincing standard proof in that written termination order, then we're not certain that that standard of proof has been properly applied and the rights of the parents have been adequately protected. And if there's no other questions, I'll ask the court again to reverse the termination of parental rights order and remand the case for reinstatement of respondent father's parental rights, or in the alternative, a new hearing on the termination grounds. Thank you.
Thank you, and thank you to all counsel. Madam Clerk?
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Thank you, counsel.